Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm very excited to share this conversation with Bobby Shukla as we talk about employment law, fighting for workers' rights, trials, and life. Bobby's Shukla Law, PC, focuses on employment law and trying employment cases on behalf of employees. Discrimination, harassment, retaliation, whistleblowing, pay equity. She's seen and prosecuted all types of predatory employer behavior. Her work has garnered all types of accolades, including being selected in the top 100 Northern California lawyers and top 50 Northern California women lawyers. Trial Lawyer of the Year finalist in 2020, and she'll be finding out within the next week if she's San Francisco Trial Lawyer of the Year for this year. She's done this while being involved in leadership in various organizations, including the National Lawyers Guild, and editor for the Trial Lawyer magazine. Her commitment to equity began early, being a founding member of UC Law's Race and Poverty Law Journal when she was a law student. I hope you enjoy this deep dive into the employment world with Bobby Shukla. If you're enjoying what we're doing here on Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts, and consider sharing an episode with a friend. Welcome to the show, Bobby.
Thank you, Miles, so much. Like I told you before, I'm honored to be a guest. I'm a personal fan of your podcast.
Well, thank you. I want to start a little bit with some background, just in terms of how you found yourself doing what you're doing now. And we can start wherever you would like as far as that's concerned. But I usually start with, what drew you into the law in the first place?
I remember having ideas about being interested in the law as a child. I'm sure my background had something to do with it, as it often does, but I wasn't conscious of it at the time. I sort of realized that later. I was raised in a family of women. I was raised by a single mother, and I have 2 older sisters. And so notions of gender and gender equity were very forefront in my subconscious, if that makes sense, and later entered my conscious as I got older in high school and college. So I was drawn to issues of equity around, I think initially gender, but also race. We're an immigrant family. I wasn't born in the country either. I have memories of not speaking English. And so all of those, of course, formed my ideas about what's fair in the world and wanting to be a part of bringing about fairness in some way.
If you don't mind, where were you born?
I was born in Brazil, though I am Indian ethnically. I'm an Indian American now, but I was a Brazilian citizen. I came to the country when I was 6 years old, but I didn't become a U.S. citizen until my 20s.
Where did you grow up when you came to the United States?
Santa Barbara County.
Okay.
Yeah. And I lived in California the entire time. And then I moved to San Francisco for law school. I went to college in Santa Barbara as well.
Is that UC Santa Barbara?
UC Santa Barbara. I lived at home the whole time.
Oh, wow.
Yeah. Now you know too much about it.
Well, and I think part of the reason I ask these types of questions is I find one's upbringing can impact one's kind of overall approach to life.
Yeah. Absolutely.
And I noticed on your bio that you speak Hindi, Portuguese, and Spanish. And I presume the Portuguese is your Brazilian background.
Yes. I have been losing it, but it was my first language. And I have a great accent in Brazilian Portuguese. So I fool native Brazilians into thinking I speak it better now than I do. But yes, it was my first language that I've still kept up here and there, but I need to practice more. Hindi I speak better because we speak it at home and I still speak it with my mother. But English is by far the language I speak the best. And then I took Spanish in school, and it's very similar to Portuguese, so it came easily to me.
Understood.
Yeah.
And is your family still down in the Santa Barbara area?
No. Recently my mother moved to San Jose about 5 years ago to be closer to my children and my sister's children, who lives in San Jose.
Are there other lawyers in your family?
No other lawyers. My mother wanted to be a lawyer, which is interesting. But life circumstances didn't lead that way. So I didn't know that until much later in life, that was her desire. My older sister is in finance, and my middle sister is a folklorist, a professor of folklore.
Interesting.
Yeah.
You all went different ways.
Yes. Yeah.
I talked a little bit in terms of going through your background that one of the things that you were involved in law school was setting up the Race and Poverty Journal. Am I getting the title correct?
That's correct.
Can you tell me a little bit about, and setting up, being a founding member of that?
Yes. Can
you tell me a little bit about how that came about?
Yeah, so it wasn't my brainchild. It was a fellow law student who had the idea. And then it was a core group of us, about initially maybe 5, and then 3 of us the following year, because the 2 graduated, that wanted to have a journal that addressed issues of race and poverty, because none of the journals at the school at that time did. And it actually was quite, it wasn't easy to establish. We had a tough time getting a faculty sponsor. We had sort of a tough time having it be legitimized and seen as official. But eventually it happened. It actually became truly official when I got funding by the school, I think, after I graduated. But we did a lot of work in establishing it. And even before we had the endorsement of the school, what was great is we were getting articles from various law professors who wanted to submit to it, because I think there were other journals like it, but not enough to address those kinds of issues in an academic, type setting. So it's something I'm proud to have been aligned with, definitely.
And it probably is straightforward from the name of the journal, and I should not just make assumptions. Can you tell us a little bit about the types of things the types of coverage that you were looking for with the material? Yeah,
it would be, fairly broad, but any issues addressing the intersection of the law and race. So it could be in any context. Could be issues around affirmative action. It could be environmental racism. It could, of course, be employment, which is what I do now. And just what a factor race is and how race impacts really every facet of American life. And that makes it, particularly hyper-focused under the law, because that's where we try and govern the rules by which we regulate things like employment and schools. And so in that sense, it's very broad, but there, of course, is never enough scholarship on it, or enough that is impacting the ways the laws are applied. And then with poverty, there's such an intersection between race and poverty, as we know. And so it was to cover those issues under a legal lens.
In terms of work, how did you find yourself in your first job, position, internship, you name it?
My first job, and it was the only 1 year that I didn't do employment law, and I did criminal defense for a private law firm in San Francisco. I'm one of, I think, few people I knew in law school that knew what I wanted to do in the law when I started law school, though I actually didn't know any lawyers when I started law school. So not only were there no lawyers in my family that I knew, but no one in the, my broader community. But because of my being drawn to civil rights issues, I was interested in something related to civil rights. And then I knew I wanted to be employment, because I thought about how much time people spend working, even though I was fairly young and never really had a very serious job at that point. But I understood that most of our time is spent working. And if that space is polluted, it affects every aspect of your life, including making a livelihood that feeds your children and, puts a roof over your head and all that. So I knew that going in. And what was cool about Hastings, when I went there 20 years ago, I don't know if it's the same now, you got an elective your first year, and the options were environmental law, immigration, something else I can't remember, and employment discrimination. So I took that elective, and then I really knew this is exactly what I want to do. It is what I ended up doing, but I didn't get a job. Even after I I was looking before, and then I studied for the bar. I didn't get a job before I graduated. Then I kind of took a break studying for the bar, and I didn't get my first job until after I passed the bar. It was the first job that came my way was criminal defense that I applied for. So I did that first, and then found a job doing employment discrimination after that. Criminal defense was interesting. It just wasn't exactly what I wanted to do, where my heart was at.
You raise an interesting point, and I think that I remember being in law school however many years ago, decades ago, and there being all sorts of opportunities for on-campus interviewing for
the big firms.
Exactly.
Yep.
And if you had a justice bone,
right,
there was the public defenders, and then there was everything else.
Absolutely. Yeah, that's absolutely right. You were in the minority. You didn't know how to carve out a way. That's how I felt, to figure out, because the jobs you're going to get are small firms.
Right.
Yeah.
How did you find your first job in
this area?
Yes.
So it's interesting because it ties to sort of a full circle type thing. My first job in employment, plaintiff side employment law, was with Pamela Price, who's the current DA of Alameda County. And you mentioned that I'll find out next week if our case that I did with Bernard Alexander wins Trial Lawyer of the Year for the San Francisco Trial Lawyers Association. And that case came to me through Pamela. She and I had litigated it. She filed it, brought me in to litigate it with her because she was campaigning, and then won her race and left the case. And so I worked for her as a brand new lawyer, tried my very first case with her. And then 20 years later, we were still co-counseling. It was kind of interesting. But yeah, that's who I worked for first, Pamela, who, African-American woman, if people don't know. And at that time and before, when I worked for her, she had already been trying cases quite a bit, but was one of few women trying case after case, was in court all the time trying cases, and even fewer Black women. So she's a true trailblazer. So I was very honored to have tried my first case with her.
Well, that's a neat background, and she certainly has been in the news
a lot
recently because there are people who don't necessarily agree with
right.
the way she's running the district attorney's office.
Right. I mean, she didn't just do employment law, though she was, I think majority of her cases were employment, but she did a lot of different kinds of civil rights cases. And, to her credit, she took this turn, and not an easy one in her career. She could retire and take it really easy because of her passion to address mass incarceration and going back to the intersection of race, poverty, and law, and how that, it greatly affects certain communities more than others. So yes, that's what she's doing now, and it's ruffling a lot of feathers.
Between she and the San Francisco district attorney, who
yes.
also took proactive steps there,
yeah.
There are a lot of people who don't like the existing system being upset. That's
correct. Right. Exactly. And that a certain type of person with a certain type of views should only be DA, and any, like you said, and upsetting that is upsetting to people. Yeah. But yeah, it's interesting. So that's who I worked for first. And then worked for I went to a couple other small firms before I started my own because I was chasing trials. So I was very consciously trying to get as much trial experience as possible. And I think you and I are contemporaries, and you have a lot of trial experience, which is fantastic. But a lot of people, our generation of lawyers, don't, because they're really hard to come by. And people who practiced law 20 years before us got a whole bunch of trials if they wanted them, right? We came about in the advent of ADR, alternative dispute resolution. And so I very consciously was going places where I could try cases, and then started working for Stephen Murphy, who is a judge now in San Francisco Superior Court, because he was a great trial lawyer and was able to, and he was a small firm. It was just him, and he would have one lawyer who worked for him. And so I was that lawyer for a period of time, and tried a bunch of cases with him, which was a great experience for me. And then when he was appointed, I started my own law practice, taking over, the cases that he had remaining as well.
And my memory of Judge Murphy is, while he really was known as a great trial lawyer with a lot of employment, it wasn't just employment. He tried all types of cases.
Yeah, his history before, I think at some point he focused on employment, but he had a long history of PI cases. He was a PI trial lawyer for a long time too. So he could do both quite easily. For example, I've never actually, have I? I don't think I've done a PI case. I think I took over one of his cases, which was a dog bite case, in my entire career. So, but yeah, he was very well versed in both those areas.
Talk to me more about chasing trials and how that showed up in your career, because there are various ways that people do that, and I'd love to hear more about how you approached it.
Yeah, so I think so Pamela also, like I said, tried a lot of cases in her career. So working for her made sense for that time being in doing trials with her, and I got that experience. The way I did is I really just consciously thought about, what's the cases I'm in now, what are the likelihood that these are going to trial, and am I going to be able to try these? Because Pamela had about 3 lawyers working for her at the time I worked for her. So it's not like I could jump on any trial, that was going forward, because other people were assigned to it. And when it looked like the experience isn't going to come soon enough, I started thinking, like, where can I go where I can get a lot more experience? So coming to Steve, I knew that whatever case was going to trial in his law firm, I'd be working on it, because he had one lawyer working for him. And then I was able to try, and made it very clear that I wanted to try cases too, but was vocal about that, desire, so that people know, like, to put me on a trial when they're going to trial. And so, and then I tried at least one case completely on my own when I was trying cases with him, which was great experience. It was a very tough case. I lost, but maybe the case I learned the most out of, in terms of like the amount I grew as a trial lawyer, would have been on that case.
And I think that's a common refrain from people, that you learn more from your losses than your wins.
Mm-hmm.
When you're thinking back on things you did and didn't do in terms of trying to develop that trial experience, and part of the reason I'm perseverating on this is one of the most common things I hear from young lawyers is, I want to be a trial lawyer. Everything goes through ADR now.
Yep.
With the Discovery Act, the group of people who tried lots of cases, who had 50 to 300 trials for the course of their lives, they're retiring.
Right.
And then there are the rest of us.
Right.
And the rest of us tend to be people who did what you did what I did, or come out from a DA or PD background.
Yeah.
So that's a long lead into, do you feel like there are other ways that you might have approached this, or other recommendations that you would give to people in terms of, like, I want to be a trial lawyer. How would I get there now?
Yeah. And I'm actually glad you're asking, because I want to share this with younger or newer lawyers. Some people are new lawyers that aren't necessarily young, right? But they're trying to get trial experience. And I think I would have done several things differently, which I recommend people do now. One is, you might not be able to second chair an entire trial if your firm isn't going to trial, but if you have friends or know people like you and I, you can come in and take a witness. Wouldn't you be willing to give, a new lawyer a witness, like an expert? I mean, you can rack up some experience that way too, or even just be there to help out if you're, available to do that for even part of a trial. I mean, that would teach you a lot, because just seeing how the arguments were made and handled outside of the jury, and how people, present certain things, all of that, every time you're exposed to that, you're learning something about a trial. The other thing is those opportunities that exist for, I think within PD's offices, where you can, there's these like short trials you can sign up for, these programs. I wish I would have done that, because that would give you real life experience really fast. Like, I wish I did that kind of out the gate as a young lawyer, right? So you can do it within the first 5 years of practice and actually handle a trial even though my understandings are pretty short and, focused, but that's perfect at that stage. And then just talk to trial lawyers, which has been so instrumental to me, because not only do you learn from them in terms of their experiences and how to do X, Y, and Z, but if people know you're eager to try cases, you're going to be on their mind when opportunities arise.
As you were developing your trial skills, were there any areas where you felt it was a greater challenge in terms of developing that skill set? Absolutely.
And I meant to say this, and it kind of ties into it, in talking about giving advice to people to try cases. I really want what I share to resonate with, anyone who's eager to try cases, but particularly women and people of color, because it is more challenging, because there is an expectation of what a typical trial lawyer looks like, and in the subconscious mind, in the conscious mind of a lot of people, and in the subconscious mind of even more people. And that person is a man, and that person is white, and that person has certain characteristics, right? Even beyond being white and a man.
6'5",
yeah, right.
Gray hair,
right?
Booming voice,
exactly.
Charisma for miles,
exactly.
Yeah.
Maybe glasses that they take off when they speak.
Yeah.
There's a definite stereotype, and so if you don't fit that, which nothing about me fits that, there is a way you have to try and own your space in a courtroom where you can garner validity.
I think it would be helpful for people to, because even if you are a central casting
right.
trial lawyer, everyone is unique in terms of
Absolutely.
how they learn to be themselves in a courtroom.
Right.
I'd love to hear how you learned to own your space and take advantage of your own special skills in the courtroom.
That's a good question. I think I'm still learning that, because it's funny. One of the things I've done, and it wasn't in relation to wanting to be a better trial lawyer. It was just because of my interest in it, was taking improv classes years ago. I have a very big interest in comedy in general. And so I took it for fun. And one thing I realized there is this whole thing about, and I'm sure actors learn this, but I never did any kind of acting, about how you take up space on a stage, essentially. And what I realized from those classes is even now just sort of naturally take up very small amount of space. I cross my legs, my arms are always like this. I don't kind of, the whole thing about man spreading on it. Like, that's just not
yes.
intuitive for me or my body at all. And so one of those things was to kind of, and not that you should do anything that isn't natural to you, but it doesn't mean you should be like all tightly, because you're cold or whatever, like in a courtroom. So kind of be aware of how I'm like using space, because the more open you are, even, there's studies that talk about, like, if your legs are sort of more spread evenly and sturdy and more open, your chest area is with your arms out, the more your body language is inviting people in rather than keeping them out. So that's like a small thing I try to be aware of, is how I'm holding space. Voice is a big thing. So early on when I did things in trials, I got feedback from lots of people, like including jurors, that they couldn't hear me, which is horrible, right? if you can't hear me, I'm going to lose. And so I've used microphones, like made sure I'm on, because often trialers don't use microphones, right? But I make sure I do. Most every time. I think there's sometimes if I'm close enough in an opening, I don't use it. But at the podium, questioning a witness, I'm aware that people often couldn't hear me.
And I'm going to ask a fairly pointed question. I've been at mediations with Marianne where she is the only woman in a room full of men, and one case in particular where we didn't hear what you said.
Right.
And when you're getting that feedback from jurors
right.
that they don't hear you or can't hear you,
right.
is it that they can't hear you, or is it that it's something different?
It's a good question. and I don't know. And I mean, what I know and what you know, because you're married to a woman who's a lawyer, is we are still very regularly not presumed to be the lawyer when we walk into court. So either the court reporter, which is very strange because if you know anything about court reporters, they always have a lot of equipment, like nothing about how a female lawyer walks into a courtroom should be presumed as a court reporter, but also the client, especially if my client is a white man. It's always the presumption by everybody that that they're the lawyer and I'm the client. And so, yeah, that has to be happening on some level, even with the jurors, like, because I think that when the woman who doesn't look like the stereotype of a lawyer is starting to speak, maybe there's something turning off about the importance of what that person has to say to the trial, because they're not, they don't look like the lawyer that I'm supposed to be listening to. But you can make sure they listen with a microphone if you need it, because they can't avoid it. Or, and that's what happens, I think, in every trial. So I think Craig Peters said this, which I've always remembered, every trial is about one thing, credibility. So what you have to do when you don't look the part is work harder to establish the credibility, but you can get there. So that's what you're doing from the beginning. Even, you're always doing that with the judge. But you're doing it with the jury, obviously, but you're also doing it with the jury, not just about your case, but about you being legitimate as the lawyer for the case, is building that credibility. And then hopefully, at some point in the trial, you've established that, yes, you are a legitimate lawyer despite subconscious biases, and that you've sort of overcome as best you can how much weight people are going to give to what you're saying, even though you don't look the part.
So as we're talking about building credibility, are there tools, techniques, other than just being human, that you have found are effective ways for you, what works for you in terms of building credibility?
I'm not sure if this answers your question, but what comes to mind, especially with a jury, is not insulting people's intelligence, if that makes sense. I think that's the strongest way that I've sort of seen that I've built credibility with a jury. So treating the way you question a witness, the way you present an opening, the way you obviously you want to do this long before the closing argument, but certainly during the closing argument, is that you present things to people in a way that there's certain things they understand because of common sense, and then bring them along with you, really just by appealing to reason. And maybe this sounds obvious, but there's a lot of strategies in how people reach juries. And I think nothing is more powerful than logic and reason, period. There isn't there's something like, oh, this is a juicy fact or a sexy fact. Like, those don't go that far as pure reason and logic. And that's the way you, I think, build the most credibility, because you're acknowledging that they have those powers and that will lead to the place you want them to go. Nothing about a show necessarily.
I think everyone brings a different set of skills in it, strengths, weaknesses, when they go into the courtroom. Mm-hmm. And I know you've had conversations with others about voice.
Yes.
And that you do trend towards a microphone.
Yes.
Are there concerns or approaches that you recommend for people with voice that you have found effective?
I mean, that one is the most effective for me. So the funny thing is, the conversation that I recall more recently on this issue was with your wife, and I was with her, and I think she got a call from you. So I could hear you and her speaking, and I could hear your voice through the phone. And you have a very deep, baritone, commanding voice, which makes it so great for the podcast as well.
There's a reason I picked a podcast as a thing to do.
Yes, it's a radio voice, right? It's
a
radio voice. And it's a trial voice, because there's studies, right, about the way a deeper voice has more authority, is presumed to have more authority and more command. And I'm sure it's tied to evolution and whatever. But now it shouldn't, right? It shouldn't have that effect in our settings, and certainly not a courtroom setting where everyone should be coming in with equal footing, shouldn't be afraid of their personal safety, et cetera. And so I just remember hearing your voice and thinking, oh, you just have that automatically, where I was conscious that people can hear me. And the way I've like learned to self sort of accommodate it is the microphone. I tried to speak louder, and you can do that to a certain degree, but then it just comes across as unnatural, where you're just almost, not even if you're not screaming, but even trying to project your voice where that doesn't feel natural. You're focused on that, not what you're saying. So that's the way I've accommodated that. One thing that I don't have to overcome with my voice is that it's not very high pitched, which I think people, and it's often it's women, but it's men too, with high pitched voices have a disadvantage, very unfair disadvantage, because it shouldn't matter in a courtroom setting. And I think you have to be authentic to yourself. So you shouldn't change your voice, and certainly not to conform to, these notions that are really sexist ultimately. But that you then have to lean on building credibility in other ways, which is what I was going back to as well, by overcoming, if you don't look the part or if you don't sound the part, you have to build credibility with your audience and the trial room or a courtroom, it's the jury in other ways. And I think it's by your knowledge and your skill and your respect for them and their intelligence that they'll come your way.
I've found that I can be an acquired taste in terms of people opening up to me. I'm not the most approachable person. I'm pretty introverted, and I do much better with a longer case than a shorter case. If I have more time to do jury selection, if I have more time to interact with the jury, I find my credibility, it's easier to gain that than if it's a very short exposure. And I'm wondering about if you've noticed any difference. If you are not stereotypical, does it take you longer to get that runway in terms of credibility, or does it come quickly for you?
I think so. But what's interesting, there's all these different, this is actually a really interesting topic. There's all these different ways that subconscious biases work. And I think some might work in my favor as well, because you just made me realize your voice is deep and commanding, but it could be maybe a little threatening on some level, right?
I definitely have to dial my voice. Yeah. I'll use a child example instead. Our son is very emotionally sensitive, and I can talk in a way that feels just like right now, like everyday voice, and he will say, "I am screaming." Like you are angry, and so what? It's actually been fantastic. It's because having somebody as emotive as him has helped me realize just how if I just put a little heat on things, it can be very scary to people, even though I don't even notice that.
Yeah. And actually that didn't dawn on me until you were talking about how you need more runway, because it could be off-putting, and it made me realize, oh, that's right. That's the thing I take for granted. The inverse is that you can be off-putting because it's commanding and it's a little like, people, I don't think people feel physically threatened, obviously, but it's part of that same part of the brain, I imagine, though I know nothing about the brain, but now I'm speaking about the brain like I do.
I disagree. I think that your experience in trial work, and I think we haven't brought up the name Karen Jo Koonan yet, but I think your experience with working with top practitioners means that you do have brain knowledge and decision-making knowledge, because those are the tools that you bring to work every day.
Yeah. I think indirectly, I certainly learned things from people like her for sure. Yeah, so it's probably part of the same brain, right, where you feel threatened. And I think I could see that you'd have to tone it down. And so it's funny to have that realization that it just seems like, oh, you've got it so easy. You've got this booming voice. But there's, of course, that other reality that I don't think about because I don't have your voice, Some of the advantages I might have is, I think, again, because of stereotypes, women can seem less threatening in certain spaces. And so that might make people warm up to me more than you, perhaps, in voir dire. So I may not need a lot of runway to have some kind of rapport, but I think I need more runway to have credibility as a lawyer. I think those are different.
I'm going to put a statement out, and whether it's in deposition or trial, see if this resonates in any way. Being unexpected. And by being unexpected, you aren't the stereotypical look.
Right.
Have you managed to be able to play that to your favor when the person most knowledgeable for the company shows up and sees you and responds a different way on videotape deposition because of who you are?
Absolutely. And then, it's what I remember is I had a professor in law school, and she was a adjunct. So she was a practicing lawyer. I think she taught professional responsibility. I can't remember her name, but at the moment. But she talked about how being undermined worked to her advantage. And I remember when I first heard that, I was like, that's ridiculous. That's so offensive, and that's so ridiculous. And of course it is offensive, but if it's happening anyways, and you can exploit it, you should, right? If you're not going to change the hearts and minds of people who are undermining you. And so that has happened to me. That has helped. If someone thinks I'm dumber than I am or less skilled than I am, they're going to be off guard than they are with someone who they think is, the real lawyer who's really smart and savvy. And it happened recently in trial. I cross-examined this one person who was the CEO of the defendant more than once, and just the way, large white man, very large, so the size difference between us, night and day, and the way he spoke to me was very, in a very quite demeaning way and dismissive way, and he's doing it in front of the jury. So that didn't get him any points.
Gifts.
Gifts. Yeah. Gifts. Yeah. So that has helped. And I don't know if he would have reacted the same way to someone who he saw as his equal.
There's a phrase that sometimes gets used, judo law, and that is taking the energy or negativity or whatever it is that the other side is doing, or your witness, opponent, what have you, and flipping that and using it to your advantage. And it sounds like you have found ways to really embrace that.
Yeah, when I'm conscious of it. And I think what's important for all of us as lawyers, like how this was enlightening, like, oh, Miles Cooper with the booming voice, that might not always work for him, is that to be aware of what is or isn't working for you and when it is and isn't working for you, but also to put aside maybe the knee-jerk reaction to it, like being angry or, and having the presence of mind to step back and say, I can use this to my advantage.
We brought up Karen Jo Koonan, and I know that she was significant in terms of work that you did, jury consultant. Are there anything from the either jury work focus groups that you've done with her, nuggets that you would feel you really would want to share with people who did not have the opportunity to work with her?
Yes. And for those who don't know, I'll just say a little bit about her. So Karen Jo Koonan, she passed away in June of 2023. And many people in the plaintiff side community loved and adored her and used her professional skills. I know you did. And
yes.
Your mentor, Cynthia McGuinn, who I know Karen Jo was very close to. But Karen Jo, she came to this work as a tried and true civil rights activist. And that was really her kind of core. She was also a mother and a grandmother. And of course, that's a core identity. But in terms of her purpose in life other than family, it was about social justice and activism specifically. And so she and I were very close. We met through a work type context when I worked for Pamela. But we then became very close personal friends because of our political views and our political involvement. And she was actually at the birth of my first child.
Oh, wow.
Yes. So we were very, very close. She was like another mother to me. So yes, I learned a lot of things from Karen Jo that I apply to non-legal contexts as well, because that's how incredibly wise she was. And touching on what you just said, the judo lawyering, you called it, that was a concept. I thought of her actually when you said that, because that's the kind of thing she talked about a lot.
It's entirely possible it's something that I learned from.
I don't think she used that phrase. Okay. So that might be your phrase or someone else's phrase. But the concept reminded me of her and the things I learned from her. And, one of the ways she illustrated different styles of quote unquote combat in the law was, there's Western style combat, and of course, huge generalization about what's West and what's East. But putting that aside, it's an easy way to describe it. In the West, a lot of the forms of combat are, you punch someone, they punch you back, and somebody knocks somebody out. And then a lot of the kinds of martial arts in the East are if someone's coming at you, you make yourself the smallest target possible, so that they miss and fall on their own momentum. And just that idea and that metaphor, she always said, apply that to what you're doing in the law, which makes so much sense. And I use that, someone's coming at you, you don't have to strike them back. That might not be the right strategy or the best strategy. Find a way where they fall on their own momentum. And momentum can mean stupidity, or can mean their racism or their sexism or their arrogance, etc.
And I sat in on her giving that presentation to our client on a number of different occasions, and each time, even though I'd seen it before,
exactly.
I felt like I learned something new and important every time I heard it.
Exactly, yeah, because she had aside from being a jury consultant, she developed her own, which is what you're talking about, method or methodology for witness preparation, which was entirely her brainchild, and she used it nationally. And incidentally, one of her daughters, she has 2 daughters and 5 granddaughters, and one of her daughters and I are working on finding a way to not let that go away with Karen Jo's passing, which she and I had talked about actually, because she knew how much it helped people in cases like you and I do, and so many others do, and she wanted it to continue to help the cause of justice in one way or another.
Is it too early to speak about that in detail, or can you give us some outlines of where you think that may be going?
I can tell you a little bit. So her daughter Taima and I are thinking of ways that maybe Taima can continue the work, because she does some similar work. So, Karen Jo Koonan was not a lawyer, and neither is her daughter, but she's she works as a legal worker as well. And so, and has a lot of her same sensibilities and intuition. And one of the conversations we had before her passing was about this and how to carry it forward. And she and I had talked about Taima finding a way to do that. So that's kind of where we're at. We've been talking about what would make sense, what it would look like.
Well, I'm hoping as that develops that both of you might consider coming back to the show. And
yeah. Oh, she's as fantastic as her mother.
Neat.
Yeah.
We've been talking a bit about trials and approaches, and I know that people are going to also be interested in terms of the type of work that you do in employment cases and how your approach in employment cases may be different than, say, a personal injury case. And that's, I'm going to start there as just kind of a launch pad. The types of cases that you handle, is there a running theme through them?
That's a good question. I really like that question. And I think so, but I have to kind of think about what it is. I think it's, if I were to come up with something, I think it's betrayal.
Interesting. And can you expand on that?
I think what happens in employment cases is it's more deeply about human relationships than I think PI cases are. And I could be wrong because I don't practice as a PI practitioner, but often there are long-term relationships. They're not about one point in time, but they're about, it could be months, it could be years of events and things that someone said. And, there's a lot of subtlety and nuance, and you have to draw inferences about intentions. And, all of these laws, you have to prove intentional discrimination. You have to prove intentional retaliation. And so how do you get to the place of, did they intend to do this? And when it comes to the kinds of harms that happen in the employment context are so deeply about human relationships, human psychology, and so I really think in each one of my cases that is a running theme, because it's not just a betrayal from the bad actor, which is often part of it, but the employer. You weren't protected. They were supposed to protect you. There was a bargain. I show up, I do what I'm supposed to do. I give it 100%. I'm doing my end of the bargain. And then when someone did X to me, you're supposed to protect me. The law, requires you to protect me, and you didn't. And I think there's always a betrayal there.
When a client comes to you, and again, what I'm looking for is the differences in a personal injury versus employment case. And I know you've done some personal injury, it sounds like.
A little bit,
but enough. So when an injured person comes to you, they have certain things that they're concerned about, fears as they go into litigation.
Yes.
Are the conversations that you have with an employment client similar, or are they different in terms of the things that they are worried about?
I think they're similar, but there's some things that are different about, I would imagine, because the risk that an employee is taking in filing a lawsuit is tarnishing the rest of their career. Because if you're suing, there's some risk I think any litigant has with being in court, and it's like, is this person litigious? Did they bring a valid claim? But if you're suing your employer, you're in a very risky place going forward, right? I've had lawyer clients, the trial lawyer case is 2 lawyer clients, but also as lawyers, we can imagine, or any profession, but this is just something you and I know. Think about being a fairly new lawyer and being wronged by your bosses and suing them. The level of courage that takes to then think about how the rest of your career is going to go, and if someone's going to give you, everyone's going to know about it really quickly, and so there's that added fear. I mean, there's the concern about litigation and what it's going to do to them in terms of taxing them emotionally and all the other ways it depletes people, frankly. But the way it's going to stain your future career is, I think, more something unique to employment cases. We've
talked a couple of times about the case that you are a finalist for. Would it be helpful to maybe just give people enough information about that case so we can use that for further conversation in terms of illustrations of other things?
Sure. So in that case, there were 2 plaintiffs, both lawyers, both women of color. They worked for East Bay Municipal Utility District, which we call East Bay MUD for short. And one lawyer who was South Asian, more experienced there for almost 20 years. And she was also the DIO, Diversity Inclusion Officer Liaison to the board, took diversity within the organization very seriously, and particularly the legal department. In 2018, when the events of the case start, the legal department had not hired an African-American lawyer for 22 years or a lawyer of color for 16 years. So the last person was the first plaintiff, whose last name is Pierce. And a very qualified, uniquely qualified candidate, African-American woman, younger lawyer, applied for a position and was passed over by the general counsel for a white candidate who we alleged, based on objective markers, was lesser qualified. So the senior lawyer complained about that. So she wasn't hired, the second plaintiff. And then, that started these investigations, and the pending investigation, the general counsel quickly hired the African-American lawyer, but then treated her like a second-class citizen in a variety of ways. And then she eventually complained. She didn't even know about the initial complaint before because it was supposed to be confidential. So the first plaintiff kept that. Then when she's being mistreated, she came to that plaintiff in confidence. There were further complaints, retaliation. That's how the case, in a nutshell, came about. But what challenging fact is they both quit. They weren't fired. And in employment, it's hard to prove that the atmosphere was so intolerable that your clients had to quit. That's the standard.
If I'm getting the phrase right, that's constructive
Correct.
termination.
Exactly. So that's never a good thing unless it's, it's typically in like sexual harassment cases when it's really bad, the jury's going to get it. But here it was a lot of, pretty subtle things. And, we had race claims, but there were no racial epithets, which is really hard in front of a jury because people, they get their head around the use of the N-word, but if there's nothing like that happening, you really have to tease it out, those inferences out. The one thing was that the general counsel had referred to, though this was a disputed fact to some degree, but he had referred to not hiring the young African-American lawyer because she was, quote unquote, not sophisticated. That was like as close as we got to a racially charged term in the case.
Thank you for listening, and tune in next week for part 2 of our interview with Bobby Shukla. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions on ways in which you have handled employment cases. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.